Major breaking news. The state of California has just been spanked badly by the United States Court of Appeals for the Ninth Circuit because they did something that I taught you about on this channel, which is you have to look down the chessboard. You have to anticipate where people are going to be moving in litigation, because a decision you make today, a statement you make today, an activity you do engage in today could potentially come back and bite you on the dupa down the road. And that's why I sometimes have to talk to you and braid some people in a polite, professional way on X to make sure that we don't commit to positions that will blow up in our face down the road, which just happened to California in this huge decision, this huge win, where the California gun advertising ban was just declared entirely unconstitutional by the Ninth Circuit. Let's break it down. Hey folks, I'm Mark Smith, host of the 4Box, a diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, we have major breaking news today. The three-judge panel in the case of Junior Sports Magazines versus Rob Bonta out there in California. A three-judge panel for the United States Court of Appeals has just found and reaffirmed, in a sense, that California's gun advertising ban that prevented marketing or advertising in any respect, gun-related products, gun-related sporting events, anything like that, to so-called minors. The three-judge panel just found that that law violated the First Amendment, which is not the first time they had reached this conclusion. They had previously said that this California gun advertising ban violated the First Amendment to our Constitution, the right to free speech, under the First Amendment, because this is obviously an activity designed to discourage people from owning guns, to discourage gun companies, and anything touching fingers with our Second Amendment right to keep and bear arms. The three-judge panel had previously said that the lower district courts had screwed up by not enjoining the law. There were games played by the district court on remand, which we're seeing more and more, of course, across this country. As in the context of, let's say, the U.S. Supreme Court makes a decision, they send a case back down to the district court, and the district court plays games. Well, that's apparently what happened here. The three-judge panel in this case of Junior Sports Magazines versus Bonta sent this case back down, saying that, yeah, indeed, on a preliminary basis, it's pretty apparent that this law violates the First Amendment, and therefore it should be enjoined. Goes back down to the district court, and then the district court plays games as to what part of the statute should be found to be unconstitutional, and try to split hairs, if you will. That's what they tried to do. So the plaintiffs in this case, after the district court refused to really honor their major victory under the First Amendment a few months ago, they went back to the Ninth Circuit and says, hey, Ninth Circuit, this district court judge is misbehaving. He's not following your rulings. He's trying to play games. Please stop this and tell him, no. Get into the corner, district court, inferior court judge out there in California. Face the corner or sit in the corner with your little dunce cap on. And that's exactly what, in effect, this three-judge decision in the case of Junior Sports Magazines out of the Ninth Circuit just did to this district court judge. But before we get into some of those specifics, let me just remind you all what this case is about. Specifically, in 2022, there was a lawsuit filed against this California statute. And here's how the court described the case right here. In 2022, Junior Sports Magazines and other plaintiffs challenged the constitutionality of a new California law that regulated the advertising and marketing of firearm-related products to minors. Junior Sports, which publishes the youth-oriented firearm magazine Junior Shooters, argued that the statute improperly burdened free speech under the First and 14th Amendments and moved for a preliminary injunction. So that's what the case was about. But what did the actual statute say? Here's what the statute that just got enjoined entirely had to say. The challenge statute has several components. First, subsection A of the statute prohibits firearm industry members from advertising, marketing, or arranging for communications offering or promoting any firearm-related product in a manner attractive to minors. Second, subsection B of the law prohibits firearm industry members from using or compiling personal information of minors for the purpose of marketing or advertising to the minor any firearm-related product. And then it goes on to point out that there's up to a $25,000 per violation enforced by the California Attorney General under this law. So that law was challenged, and ultimately the Ninth Circuit said, hey, look, this is free speech. Yes, it may speak to what's known as commercial speech, but commercial speech that speaks the truth about an honest product and a lawful product, which firearms are lawful. We have a constitutional right to them, for crying out loud. Even under intermediate scrutiny, as applied to restrictions on commercial speech and advertising, there's no way that this particular law can stand. Now, remember I said at the start of this video that I sometimes have to be firm with my friends in gun YouTube land and also other Second Amendment supporters to make sure that they don't take positions that will come back and bite us on the butt. And I explain the way to think about this metaphorically is when you make a legal decision as an attorney in court or otherwise, right? You have to envision in your mind, this is how I always did it as a trial lawyer, a big spider web, okay? That spider web is your situation, your case, in this context, the Second Amendment right to keep and bear arms. And when you pull a strand, a single strand, by making a legal argument or taking a legal position or bringing a lawsuit, whatever it might be, when you pull on a single strand in that big web, the entire web moves, right? You pull one strand of a spider web, the entire web moves. And it's mission critical if you're an excellent elite lawyer or other person in this space that you understand how the web's going to move. Now, the reason why I say this is that California got their dupa kicked here. Why? Because the Ninth Circuit said to California, wait a minute. You're trying to say you can't advertise or market gun-related products to minors. And here was the mistake California made. However, the Ninth Circuit pointed out that the state of California actually encourages the demand for gun use by minors because they give, ready for this, folks, permit discounts for young hunters. That's right. In this opinion specifically on page 4, the Ninth Circuit literally says, come on, California, don't be saying that, people in the for-profit center cannot make honest, truthful advertising statements involving the Second Amendment or guns to minors when you literally, as a state, you literally encourage the demand for gun use by minors by giving them discounted hunting licenses at a rate that's below what an adult, a full-blown adult, would pay for those same hunting licenses. So you, California, are literally encouraging the use of guns by minors. That's an example that we talk about on this channel, a position that California took elsewhere in the context of hunting, came back, and in this case involving the right to free speech under the First Amendment as applied to guns, it got them kicked in the dupa, came back and bit them on the butt. And that's why when I make comments on this channel, I'm going to digress for just 10 seconds here. When I make comments on this channel to don't say stupid crap about things like Justice Barrett or some other things, I do it out of love for you and the Second Amendment, because there's certain things I know if you take positions on, even at one level, sounds great, perhaps your gun club or in the bar, it will eventually come back and bite us on the butt. And that's why this channel, to some degree, exists, because this is complicated stuff when you look down the chessboard and try to figure out how the entire Second Amendment spiderweb moves when, for example, there's an opinion by the Supreme Court involving like an administrative agency in the deep state. You're like, why do we cover this stuff? It's not the Second Amendment. The answer is, if I'm covering it, it does indeed touch fingers ultimately with the Second Amendment. And here's a perfect example. No one in California obviously connected the dots between giving discounted rates and fees for hunting license to kids. In that state, no one thought about that when they were figuring out how to deal with this law dealing with advertising of gun-related products and gun-related services and gun-related information that might be attractive to minors. They didn't realize that this inconsistency in court years down the chessboard or years down the road was going to come back and be used against them and blow up their entire case, destroy their entire statutory law of the California gun advertising ban, because they did not apparently connect the dots and understand that this disconnect was going to be the metaphorical portal in the Death Star that would cause the entire Death Star to get blown up when you hit it precisely. So the last point I want to make about this great decision, which I'll put a link to it in the description here, is for those of you who are Saturday Night Live fans from the 70s, I wasn't really around then, but a lot of you were, there's a very famous skit on Saturday Night Live between Jane Curtin and Dan Aykroyd, where Jane Curtin would make certain statements, and then Dan Aykroyd would say, "Jane, you ignorant, blah," and then would try to correct her. And it was a big skit. It was very funny. It was used in the 70s throughout Saturday Night Live. Now, the point is when I read page 6 of this opinion, I actually, in the back of my mind, could hear Dan Aykroyd making that funny satirical comment to Jane Curtin on Saturday Night Live, because the big issue in this case was the district court was taking the position that the Ninth Circuit, when they issued their first ruling in favor of the plaintiff junior sports magazines, was not clear about the scope of the ruling, and the district court tried to say that the ruling of the Ninth Circuit was very narrow or relatively narrow, and now the Ninth Circuit looked at this and said, nah, it was pretty clear what we meant. And we talked about that the entire statute was unconstitutional, not just a portion, because the district court was saying a portion of the statute was unconstitutional, not the whole thing, according to the Ninth Circuit. And the Ninth Circuit today, in the 3-judge opinion, just says, nah, it's the whole statute. And if you look at what the court says, you can see what I'm talking about. On page 6, they literally say, our prior opinion addressed the statute as a whole, and not just subdivision A. Then it goes on to use the phrase, we began by framing the parties' dispute over the entire statute. And then it goes on to refer to the statute subdivisions as parts of the integral whole. You see what I'm saying? So as I'm reading these words, the whole statute, the entire statute, the integral whole, I'm immediately thinking like, oh my God, this sounds in the back of my mind like Dan Aykroyd saying to the district court, hey, district court, you ignorant, blah, blah, blah. I'm not going to use the word, but you get exactly what I'm saying. And I thought it was quite funny. It's pretty clear the Ninth Circuit is like, dude, you got to get this right. Stop screwing this up. We refer to the entire statute, the entire California gun advertising ban being unconstitutional. Get it right, district court. Don't make us spank you again. And by the way, I have a feeling that if you talk to these 3 judges about what they were thinking, it would not shock me if they are observing what the United States Supreme Court has recently been doing with these lower courts in a lot of these Trump-related cases, basically saying, you lower court, inferior courts under Article 3 of the Constitution, you need to get your act together because you keep screwing this up. And we, even sometimes Justice Kagan is like to the lower courts, you guys are going crazy. We got to fix this stuff because we're seeing a trend over the last several months of the United States Supreme Court spanking these inferior district court judges and courts of appeals for blowing up the Constitution and not following the law. And it was very interesting to see a similar effect right here by this Ninth Circuit decision speaking to the district court. I do wonder whether or not the lessons from the Supreme Court are seeping out to the U.S. Court of Appeals and trying to create a little bit more of management and guidance and overall monitoring of these lower court behaviors to make sure they get it right and don't go off the rails. But one does wonder whether the Ninth Circuit took a little bit of lesson here from the recent decisions by the U.S. Supreme Court ruling in and calling to task the lower courts, which I think overall is a very good trend for us in the Second Amendment community and beyond. So overall, a very big win. Congratulations to the Second Amendment Foundation, the Gun Owners of California, the California Rifle and Pistol Association, and all the other great plaintiffs that helped win this case. Congratulations to you all. Big win for the First Amendment, which, of course, you need to be able to talk about the Second Amendment and guns using your First Amendment rights to support the Second Amendment. The First Amendment and Second Amendment work together to reaffirm each other, so they have to go together to protect all of our fundamental rights as American citizens. So that's great news. Congratulations to all of you out there in California for this big win. And again, if you haven't followed me, make sure you follow me on X at 4Boxes Diner. Don't forget to subscribe both to YouTube and to Rumble, and we look forward to talking to you again real soon here at the 4Boxes Diner.
Orders up. Table 2A.